I hope you had a good holiday and we're ready to go back to work. So I'll call this meeting of the Municipal Planning Regular Council meeting to join together at 9:30 a.m. And I'll confirm that all members of council are here as well as our municipal clerk. I'll read the territorial land acknowledgement. We respectfully acknowledge the Township of Allen-McCullough is located on the Mississauga-Neshinembig territory and is the traditional territory of the Mississaugan-Neshinembig. The Township of Allen-McCullough respectfully acknowledges that the Mississauga Nation are the collective stewards and caretakers of these lands and waters in perpetuity, and that they continue to maintain this responsibility to ensure their health and the integrity for generations to come. Approval of the agenda. That the agenda for the municipal/regular council meeting held on April 22nd, 2025 be approved. Can I get a mover and a seconder? Moved by Councillor Booth, seconded by Deputy Mayor Stover. Any discussion? All in favor? That's carried. Disclosure of pecuniary interest or general nature thereof. Seeing none, that'll be noted. Minutes, right? Minutes. Okay. So we're going to move on to the land division / committee of adjustment meeting. So I'll need a mover to go there. It is recommended the council of the corporation of the township of Allen-McCullough and act as follows. The council of the township of Allen-McCullough, being a land division committee or the committee of adjustment, move to a land division committee of adjustment meeting at 9:31 a.m. Mover and a seconder. Moved by Councillor O'Neill, seconded by Councillor Ainsworth. Any discussion? All in favor? That motion's carried. And I will confirm that we have the secretary treasurer here from the committee. Welcome, Tracy.
Good morning. Thank you.
And we'll start the meeting at 9:31, as I just mentioned. Territorial land acknowledgement. We respectively acknowledge that the Township of Allen-McCullough is located on the Mississauga-Neshinembig territory and is the traditional territory of the Mississauga-Neshinembig. The Township of Allen-McCullough respectively acknowledges that the Mississauga Nation are the collective stewards and caretakers of these waters and lands in perpetuity, and that they continue to maintain this responsibility to ensure their health and integrity for generations to come. And we got another agenda to approve, that the agenda for the Committee of Adjustments / Land Division Committee meeting held on April 22nd, 2025 be approved. Could I get a mover and a seconder? Moved by Councillor Booth, seconded by Councillor O'Neill. Any discussion? All in favor? That's carried. Disclosure of pecuniary interest or general nature thereof. Seeing none, that'll be recorded. And our next business is the motion to adjourn the meeting minutes of March 25th, 2025. It is recommended that the council of the committee of adjustment, land division committee of the corporation of the township of Allen-McCullough enact as follows. That the minutes of the committee of adjustment, land division committee meeting held on March 25th, 2025 be approved. Moved by member Stover, seconded by member O'Neill. Any discussion? Go ahead, Councillor O'Neill. Or I'm sorry, Councillor Stover. Member Stover. Got to get these names all right. They keep switching them on me. Not the people, but just the minutes we're into.
Thank you, Mayor Logal. Mayor Logal, I just wondered if I could ask Madam Clerk a question, if there isn't, well, maybe I should be asking Tracy, our planner, about if there's an update of when a member of the Alderville community would be attending a future meeting.
We are hopeful that they'll be here for May the 20th for the committee of the whole. They were unable to make the deadline for the last committee of the whole agenda.
Okay, thanks so much.
You're welcome.
Thank you, Mayor Logal.
Okay. All in favor? Motion is carried. Now we're going to move on to applications. And the first application for consent is for James and Leanne Hall. Tracy, do you want to take us through this one?
Okay, thank you. The purpose of application AH 24-2024 and AH 25-2024 is to sever a portion of the farmland, retaining the existing house, farm buildings, and some farmland, and to create a vacant rural residential lot. An easement will be required for shared access between the farmland that is subject to application AH 24-2024 and the vacant rural residential lot that's subject to application AH 25-2024. The proposed lot area for the residential lot is 0.4 hectares and the severed farmland is 65.52 hectares with a 13.16 hectare lot to be retained. The subject property is located on the north side of County Road 24 in the northeast area of the township, approximately 300 meters from the border between the township of Alma-Caldeman and the municipality of Trent Hills. The property is developed with a single detached dwelling and 2 livestock barns, which are located near the center of the property. The property was originally 2 parcels that have merged. Most of the property is cleared and actively farmed. Approximately 3 hectares in the northwest corner of the property remains forested. There's 2 tributaries of Percy Creek that flow northeast and east through the eastern portion of the lands. The on-site livestock barn houses approximately 50 beef cattle. Surrounding land uses are almost exclusively large agricultural properties, with the exception of the property immediately across the road from the house. The dwelling at 12699 County Road 24 was severed from a 20-hectare agricultural property and rezoned to rural residential in 2020, which means that the barn on the property can only be used for a hobby farm with a maximum of 2 livestock units. Livestock barns in proximity to the proposed residential lot were identified on the retained lands and at 12838 County Road 24. Most of the surrounding lands are under active agricultural cultivation. The PPS requires that it does acknowledge the agricultural use in the rural section of the PPS under 2.5 and 2.6, which does permit rural lot creation and the agricultural uses. Section 4.6 does not permit development and site alteration on lands containing archaeological resources or areas of archaeological potential unless the significant archaeological resources have been conserved. Compliance with MDS is a requirement of both the PPS and the township's official plan. The livestock barns on the subject lands at 12838 County Road 24 are similar in capacity and both appear to house cows. An MDS calculation was prepared, resulting in a 197 meter or 646 foot MDS setback for the proposed rural residential lot. The lot is outside of both of the setbacks for the 2 properties. The Northumberland County's official plan also designates the property rural. It also permits the rural lot creation and agricultural use. The property is not, it was noted that the property is not significantly disturbed and contains a pond and water courses, so they suggest that an archaeological site assessment be prepared, and that comes from the county. In our official plan, the property is designated rural as mentioned, which does facilitate the farm and rural lot, residential lot creation. The property does have frontage on an open year-round municipally maintained road, which is County Road 24. Northumberland County has reviewed the frontage to determine a safe access point. As only one safe point was determined, an easement over the retained and severed lots created through AH 2024 is required to provide shared access to both severed agricultural and residential lot. Section 7.4.2 indicates that the sites with archaeological potential shall require an assessment to be undertaken by a licensed archaeologist as a condition of approval for the development applications. The proposal is consistent with the PPS and both official plans provided archaeological potential is addressed. The application was circulated to a number of departments and agencies. Our Public Works Department has no concerns since the application is on County Road 24. The Building Department also had no concerns with the proposal. Northumberland County had originally requested that application AH 25-2024 be deferred at the January 15th, 2025 committee meeting. That provided the opportunity for a meeting to be had to identify the best point of access and how to configure the easements. Their Public Works Department has advised that to achieve adequate safe site distances as a condition of severance, the proposed west severed parcel created by AH 24-2024 and the retained parcel must provide an access easement to accommodate a shared vehicular entrance across the south portion of its lands running easterly and parallel with County Road 24 to allow for the proposed severed residential lot through AH 25-2024. They've also asked for a road widening of 15 meters across the frontage of both the retained and severed parcels. Prior to construction, the temporary or permanent buildings and structures on the retained or severed lands, the applicant must apply for a county setback permits. Waste management had no concerns and noted that waste collection can be provided in accordance with their bylaw. Before issuance of a building permit for the new residential dwelling, a sewage system permit would be required. Northumberland County requested the applications be approved, provided that the conditions are satisfied. And again, they suggested that an archaeological site assessment be prepared. Lower Trent Conservation had no objections to the approval of the application. The owner has been provided with detailed comments, so they're aware of the portions of their property that are regulated through Ontario Regulation 4124. The school board, Kawartha Pine Ridge District School Board, had no concerns or issues related to their mandate. No comments were received from the balance of the circulated agencies. Notice of this application was circulated to all owners of the land within 60 meters of the subject property, and a sign was posted. I did receive a call from a resident about the point of access, and once they had learned the exact location, they had no concerns with the proposal. As noted, the proposed severed lots are located within a rural part of the municipality on County Road 24. Northumberland County reviewed the sight lines, determining the safe point of access, and the proposal will require a shared driveway at that location. There are no impacts to natural or natural hazard features on the subject property through the applications. The proposal is conforming with the MDS setback calculations. The residential lot was positioned in a manner to meet those setback requirements. Because there are water sources on the severed agricultural lot, the checklist provided by the Ministry of Tourism, Culture and Sport with criteria for evaluating archaeological potential indicates that development within 300 meters of water sources need to be assessed. Since the proposed agricultural lot is significantly large at 65.52 hectares. Future development may or may not meet that criteria. Rather than require an assessment over such a large parcel, a condition is proposed requiring a development agreement to be registered on the title of the severed parcel to secure for the completion of an archaeological assessment should future development meet the criteria for evaluating archaeological potential. So the application is proposed to be approved with the standard conditions, and in addition, requiring the part on the proposed reference plan to include a road widening at 15 meters and a vehicular access easement, as noted. And there will be a requirement for rezoning of the rural residential lot to address the lot area, and for the development agreement to address archaeological potential should development be proposed in the future. Thank you.
Thank you, Secretary Treasurer. Any questions or comments from council with this application? Go ahead, Councillor Ainsworth, Committee Member Ainsworth.
Thank you, Mayor. I just have maybe I could get some direction from our Madam Clerk also. With the upcoming meetings that we have with Alderville First Nation, and I know these archaeological assessments has been gone to the province, and it's also gone to Doug Ford about the policy and the way things are being handed out. So I'm wondering at this time, could we make a decision to red circle anything that we're doing when it comes to archaeological assessments? Because if we come up with a procedure and maybe a committee and at looking at each individual one, deciding whether it needs to be done or not, because we have had multiple arguments about whether they should be or shouldn't be, and that we could go back to all these ones, and have another look at them if we come up with a committee and after we talk to Alderville First Nation. And we need a dispute resolution if we don't agree with it. I don't think at this point that the residents, most of the residents, maybe the new ones that are here today, understand the cost of this archaeological assessment and the stress that it probably is going to put them on financially. And I think we need to determine that.
Tracy, you want to comment?
Yes, through the chair. So in this case, because the lot is so large and we don't know if development will happen on the agricultural proposed lot, within the area of potential, which is not dictated by Alderville, it's dictated by the ministry. So I think we need to make sure that that is clearly understood. I have talked with the ministry staff. The checklist is very clear. If somebody wants to dispute a condition of the approval, they have the ability to appeal to the Ontario Land Tribunal. I believe the Ontario Land Tribunal will probably review the application in accordance with that checklist as well. So the result may not be different. Because the approval is a conditional approval and it takes people have up to 2 years to complete the conditions. There is also the opportunity, if something happens to change, which I'm not confident that it will, we could look at coming back with another report to amend the conditions if we learn something in the coming weeks. But for my conversations with ministry staff, the approach that I am proposing is in line with their understanding from what I have understood from our conversations.
Thank you, Tracy.
Thank you.
Any follow-up? Go ahead, Joan.
Thank you, Mayor Logal. Tracy, or Madam Planner, Madam Secretary, I noticed on page 3 of this report that the property was redesignated from agriculture to rural. And I was trying to find the minutes that pertain to that. And I just wondered, when I was trying to get it registered in my mind, I was just wondering if I was missing something, because it was agricultural. Is the reason because it's marginally valued as agriculture?
Through the chair, I'm just, from my understanding, the property is designated rural. It is used as an agricultural use, which falls
Mhm.
under the rural designation. So it's not designated agricultural at this point, but it is designated rural, which also accommodates agricultural uses. Does that help? I'm just wondering if I'm missing.
Go ahead,
On
committee member.
page 3, Mayor Lowell, if I may, to Madam Planner, the surrounding,
Oh,
okay, the dwelling at 12699 County Road 24 was severed from a 20 hectare, is that hectare agricultural property and was rezoned rural residential. So did I read that right, that it was agriculture and then was rezoned?
so this is speaking about the property that's across the road from this property.
Ah,
So, and the description of the land uses is not referring to their designation in the policy documents. It's referring to how the property is actually used. So the
Ah.
property across the road was a larger, it's also designated rural, I believe, but it was used for agricultural, and then they had a severance for a residential lot. And then because of the proximity of that barn to that residential lot, they chose to rezone that property so that they couldn't have livestock because of the MDS setback requirement.
Thank you for the clarification.
You're
Because it
welcome.
wasn't registering right, and
Mhm.
thank you for that. Thank you.
No problem.
Councillor Ainsworth.
Through you, Mayor. So just to follow up on the archaeological stuff. So is it safe to say that if we come up with some dispute resolution for the archaeological assessments, that we can come back to these reports and have another look at whether they should be done or shouldn't be done?
My understanding of it is that that's a provincial policy statement, and yes, that could be solved by resolution, but not at this level. That has to go to the province, the minister, to do something like that.
Through you, Mary, yes, and that's kind of what I'm saying. So we have the meeting with Alderville First Nation, we have a meeting with our MPP. We might put a committee together here at council. If we do that and we have a dispute resolution, whether they should be done or shouldn't be done, or what the criteria is for it. Can we go back and reassess these applications? That's the question that I have.
Go ahead, CAO.
Through you, Chair. My understanding is that if this is ministry, so provincial policy, if the ministry changes the policy, I do believe that it would probably come back because it would change it for everyone. So I'm not sure whether you need to do that at this point. If there's meetings being had with Minister Piccini and Mr. Ford, then I would expect that may come back and we would seek direction. As far as our planner's responsibility is to uphold the policies of the province. And obviously it's up to council if they choose to vote for or against.
Okay. Again, also is that I just want to clarify this because I just don't want to keep bringing it up every application. Because it's on every application today.
Okay,
All right. And I don't agree with either one of them. So I just want to clarify that. I know I don't want to hold anybody up, but at the same time, we need to have a dispute resolution for it.
go ahead.
Thank you.
I'm actually listening to something and I need some clarification. Who is meeting with the province and member of provincial parliament?
I don't think anybody is at this point. It's just been, emails, phone calls.
And certainly as a council, we have not authorized any statements on our behalf that are counter to what it is the law of the province.
Any further discussion? I'm going to open it up to the public then.
Thank you.
Thank you, Mike. Members of the public, do you have any questions or comments on this application? Seeing none, how about the owner of the property, the applicant? Do you have any comments, James?
Can we check to see if anyone is
Oh, on
online?
the line, yes.
Thank you.
Anybody on the line that wants to make a public comment regarding this application?
Yes, please. It's Grit Cole.
Go ahead, Ms. Cole.
There's been a lot of discussion at these planning meetings regarding the archaeological studies that have to be done. I recently did some research into this, and what has happened in the past decade is an agreement has been reached that any lands that have been designated of archaeological significance for Indigenous peoples are to be assessed if any development is requested on any parcel of land. So regardless of whether it's a small portion for a garage, or whether it's a house, or whether it's putting in a swimming pool, the property itself needs to be assessed because it goes beyond just whether there's any archaeological artifacts or human remains in the position where the project is going to occur. It also becomes a history finding process. And this has been legislated now. So I'm not sure anyone that, that good old expression, and I hate it, buyer beware. But in this case, anyone that buys in an archaeological designated area really has to think hard and long about whether they want to do any further work on their property, because that's what the legislation says now. So if you want to go and say that it doesn't matter what the Aboriginal people have worked so hard to get their burial grounds and their camping areas, their settlement areas to be studied. I mean, you think about archaeological digs around the world. They're
Excuse me,
very
Ms. Cole,
much
I think you're
protected.
getting a little bit off subject. Really,
No, I'm just pointing to the fact that this is legislated, it's in place, it has to happen because they want to know if there is anything in the area.
Yes,
So
I
I'm just
understand that.
thinking that we need to stop trying to circumvent something like this. That's all. Thank you.
Okay, thank you. Committee member Stover, do you have a comment?
Thank you, Mayor Logal. I forgot to ask one question.
Ask through me, please.
I will. Thank you, Mayor Logal, to Madam Planner,
All
if
this,
I may.
just ask to me. And
Okay, so my question was that the agricultural land mass was 0.4 hectares, which isn't quite 1 acre. And I just wondered, my note here is 0.988 of an acre. So I just wondered why it was not at least an acre, because that is the size of most rural lots. So that was just my question.
Thank you, Madam.
Through the chair. So the 0.4 hectare severed lot is for the rural residential lot. And the zoning bylaw, the regulations are spelled out in metric. So 0.4, when you round up 0.4, when you convert it, it is equivalent to about an acre.
Thank you.
You're welcome.
Mayor Logal, thank you.
Thank you. Councillor Booth.
Through you, your worship, to the planner, if you can hear me. I'm just wondering, is there a map that we could be supplied with to council in the future that would show what areas in the township do fall under this? Is there a map that shows, something that can give us a general idea, and that we can show residents that, it's more than likely you're going to need an assessment because you're in this shaded area?
Go ahead.
Through the chair, we don't currently have a map that maps out archaeological potential. The official plan does speak to recommending an archaeological master plan to be done at some point in the future, which would require some financial resources. I can look at possibly doing that through the official plan review. When we put a terms of reference together, we could do that. What I could do is provide everyone with the criteria. The criteria speaks to information that we do have, like mapped water courses, but it also speaks to information that we don't necessarily have. So there's a lot of questions that rely on Aboriginal knowledge. So when somebody is filling out the questionnaire, if it's not within 300 meters of a water course, which is a given for an assessment, then we can reach out to Alderville to get their information. They're more than happy to share that with people. When I do meet with applicants before they submit an application, I do flag this as a potential requirement. So we typically will sit down with an applicant in the office and go over what their proposal is, and we bring up the mapping on our screen so that they can see what is available that I can share. I also have mapping that is confidential that was provided by the ministry that shows known sites of archaeological resources. So if there is an application within 300 meters of those known sites, that is another question on that questionnaire that says they must do an assessment if they are within 300 meters of a known site. Thank you.
Okay, we're going, okay.
Just a comment of that through your worship is just, I think it would be helpful in the future if you have some kind of general map. That way, if councillors get asked or people just want to go into the township and look at something quickly to see, oh yes, I'm not really affected, I don't think, or because I think a lot of the arguments too is what's considered a water course. We have lots of stuff in the springtime where we get water running down, but then 11 months out of the year, there's nothing there. It's dry. So what really is considered a water course and what isn't? But that's good that you're having these meetings, and maybe in the future we could be provided with something. Thank you.
I think it's proper that we take up as Councillor Booth has mentioned, and if we can get something in the plan when we're doing it again, it's probably the right time to take a look at that. Agent, I believe Serraris. Do you have a comment?
Studies and the time frame.
Can you answer that, Madam Treasurer?
Through the chair, I can't specifically answer it. It would depend on the scope of the work that would need to be done, the size of the area. I've been recommending people get quotes from archaeologists. I had heard from someone recently that it's a smaller project and it was about $3,000 they've been quoted, but there have been other quotes where it was closer to $10,000. So it depends on the nature and scale of the work, and the applicant should be getting those quotes. Thank you.
And check it out. Don't take the first one necessarily, because they can jump around. Anybody else have any further comments? I'll read the motion and hold on. Applicant for consent, James and Lee Hogg, PLN 2025, applicant for consent. And it's 22nd of April, 2025. That applications to AH 24024 and AH 252024 be by James and Lee Hogg to sever a parcel of land for an agricultural lot and the creation of a new rural residential lot in concession 3 part lot 23 and 24 geographically in the township of Alnwick be approved subject to the following conditions. To submit a draft 3R9 reference plan prepared by an Ontario land surveyor to the satisfaction of the County of Northumberland and the Township of Alnwick, which illustrates the following. A part on the plan for a minimum road widening of 15 meters from the painted center line of County Road 24 along the frontage of the retained and severed parcels. A shared entrance illustrated on the severed parcel directed across from 12715 County Road 24. And a part on the plan for a vehicular access easement on the west severed parcel created through the consent application AH242024, benefiting the retained parcel and the eastern severed parcel created through the consent application AH252024, which travels across the south portion of the severed parcel from the proposed shared entrance running parallel with County Road 24 connecting into the retained parcel. And item D, a part of the plan for a vehicular access easement on the retained parcel benefiting the eastern severed parcel created through consent application AH2024, which travels across the south portion of the retained parcel running parallel with the County Road 24 connecting into this severed parcel. Number 2, to submit a deposit 39R reference plan for the township and the county, which illustrates the above noted requirements under condition 1 and the several parcels. Number 3, in addition to the registry survey, a geo-referenced DWG file of the survey be provided in a format satisfactory to the township in Northumberland County, that a draft transfer and certificate of official from the severed parcels and road widening be submitted to the township. Number 5, that the owner applicant deeds road widening to the County of Northumberland at their expense and that it is free and clear of all encumbrances. Number 6, that the tax account for the subject property be paid up to date. Number 7, that a zoning by amendment be in effect for the severed parcel subject of the application AH24-2024 pursuant to the Planning Act, that a development agreement be registered on the severed lot subject to application AH24-2024 requiring an archaeological assessment should future development meet the criteria for evaluating archaeological potential provided by the Ministry of Tourism, Culture, and Sports. That $12,796.34 development charges for the severed lot be paid to the Township of Allen-McAlderman, and that cash in lieu of parkland to be paid to the Township of Allen-McAlderman at a rate of 5% of the value of the land the day before approval was granted. The value of the land is to be determined by a certified appraisal or sale price of the land, provided it occurs within 12 months of the approved date. Since the intent is to provide cash in lieu for residential use, the appraisal for the agricultural lot subject to application AH2024 shall be based on 0.4 hectares. That $300 be paid for the issuance of the certificate of official or in accordance with bylaw 78-2024 fees and charges bylaw. Can I get a mover and a seconder? Moved by Councillor Booth, second by Councillor Ainsworth. Any further discussions? All in favor? Motion is carried. Thank you. Next, we're going to move on to application for consent, Curtis and Liz Wilson, AH262024. Madam, please go ahead.
Okay, thank you. Well, the purpose of application is to sever a 0.4 hectare residential lot retaining a 6.93 hectare lot with a single detached dwelling. The subject property is located on the west side of North Street, south of Shelter Valley Road. It is partially within Vernonville, a designated settlement area in the southeastern quadrant of the municipality. The balance of the property is within the rural area and is not a part of the proposed lot. Surrounding land uses are residential to the northeast and agricultural uses to the south and west. There is a single detached dwelling and accessory structure on the property. The property was largely cleared with a forested area in the northwest corner. Large agricultural fields are located south and east. Shelter Valley Creek is located approximately 62 meters north of the property. The property is designated rural and hamlet in the township's official plan. Section 2.5 and 2.6 of the PPS directs development to rural settlement areas, and consideration is given to appropriate rural characteristics, the scale of the development, and the provision of appropriate service levels. The proposed severed and retained lots are appropriately sized to accommodate private services with frontage on North Street, which is a year-round municipally maintained road. Section 4.6 does not permit development and site alteration on lands containing archaeological resources or areas of archaeological potential unless the significance of the resources have been conserved. Due to the proximity of Shelter Valley Creek, there is potential for archaeological resources. No natural heritage features or hazards were located on the subject property, and there are no lands regulated by Lower Trent Conservation Authority. The county's official plan designates the area subject to the severance as rural settlement area. And the county's OP supports residential lot creation in that designation. The township's official plan also designates the property as hamlets, which is the focus of growth for the township. No natural heritage or hazard features were identified, and section 7.4.2 indicates sites with archaeological potential shall require an archaeological assessment to be undertaken by a licensed archaeologist. Provided the archaeological potential is addressed, there's no concern, or the proper proposal is consistent with the PPS and conforms with the intent of the Northumberland and Alnwick official plans. The area where the lot is proposed is currently zoned hamlet residential. That zone is also applied to the area where the existing single detached dwelling is located. That zone requires a minimum frontage of 38 meters, and the proposed severed lot frontage is 30.78 meters, and the retained is approximately 16.2. A rezoning is required to address the lot frontage. It's noted that the proposed lot line could be adjusted on an angle to provide optimal lot frontages for both lots. However, there is adequate frontage proposed to accommodate access and the required setbacks. The application was circulated to a number of departments and agencies. Public Works advised that an entrance permit would be available. The township's building department indicated that a grading plan at the time of building permit is required to ensure drainage does not impact adjacent properties. Northumberland County had no objections with the proposal. They noted that residential waste collection would be provided and a sewage system permit is required to serve any new dwelling. Lower Trent Conservation Authority indicated that there are no natural hazards on the subject property and no features on these lands that are regulated. Notice was circulated to all registered owners of the land within 60 meters, and a sign was posted. One resident visited the planning department to express concern with potential runoff from the proposed lot onto his adjacent property. The subject lands are located in Vernonville, which is a designated settlement area. The approximate 3-hectare portion of the property located within the settlement area is large enough for the residential development. Previous severances along Shelter Valley Road have limited the available frontage on North Street for lot creation on the subject lands. Consideration of reduced lot frontages will optimize the ability for lot creation. No concerns were raised during the agency circulation. One concern was raised from the public about potential runoff from the proposed lot onto adjacent properties. To address this concern in recognition of the topography, which is sloped considerably from south to north, a condition for development agreement to secure a grading plan at the time of permit submission is proposed. So in addition to the typical conditions, there is the requirement for an archaeological assessment, the development agreement for securing of the grading plan and a zoning bylaw amendment. Thank you.
Thank you. Tracy, there's the two lots, the one that retained and the severed, then there's one right beside that one?
So there's a property to the north with a fairly
Yeah.
new house constructed on it. And then there's as North Street bends, there's a lot to
narrow
the, yes, but it's a quite a large lot.
Yes.
That is to the east, fronting on Albert Street.
So could that be, is that big enough to put
I'd
another-
have to look at the air photos to see if it's already got a house on it, but it looks like there's adequate frontage. I'm not sure if they
Okay.
have frontage on the street that runs north-south that is located east. I'd have to look into that.
Okay, thank you.
But they would have to come
Yeah,
and
it's really
have a
got nothing.
chat.
Yeah, it's really got nothing to do with the application anyway, so I don't know why you asked it, but I was just curious more than anything.
Okay.
But it does require archaeological
Yes,
assessment because it's so close to the river, Shelter Valley or creek. And it also requires a grading.
that's
And
correct.
that's the one that's up in the hill and it could really go down on it. Okay,
Right.
thank you. Questions? Council, or pardon me, Member Ainsworth.
For you, Mayor, just a clarification. And to nobody's fault. But the little stream that runs alongside Shelter Valley Road in Vernonville is not Shelter Valley Creek. It might be a contributory to it,
Oh,
but the Shelter Valley Creek is about over a kilometer away. And it has the little stream in Vernonville, and it has the stream that goes up McDonald Road that conveys into it. So I don't know what they call that little stream that comes through Vernonville, but it's not Shelter Valley Creek.
Thank you. Do you have a comment on that, madam?
it likely is a tributary and
Yes, it would be that.
yeah, apologies for that. I'm not sure if it does have a name. There are quite a few tributaries that are unnamed. I don't see a name that comes up on my mapping.
Okay. That'll be noted.
Thank you.
Anybody else have any questions or comments? Councilor O'Neill.
Chair logo, we'll try it between us. And I apologize for asking because I hadn't noticed this before I was sitting here, but the severed lot, we acknowledge that they have road access. It's the retained lot. I see it's kind of only there right on the corner itself. Did Public Works look at that to ensure that they retain access to the road in the retained section?
Tracy, you want to answer that first, please?
Yeah, through the chair, they did have a look at it and had no concerns with the ability. There's already a driveway for that retained lot. So when they prepare the survey, they'll make sure that the driveway is fully within the retained lot. I would suggest to the applicant that they should probably have the survey done prior to making the application for the rezoning so that we know the exact number that we're dealing with.
Thank
Thank you.
you. Any other members of council have any comments? Does the public have any comments regarding this application? Anybody on this? We have people that are attending virtually. Do you have any comments?
Oh, hi there, Mayor Logal. This is Curtis Wilson. Can you hear me there?
Yes, we can. Hello? Yes, we can, Mr. Wilson.
I just had two. I'm sorry. Can you hear me now?
Barely, but we can hear you.
Oh, I'm sorry. Is that any better? My apologies.
Give it a try. We'll see what happens.
Okay, I was just going to address the lot frontage. I do my mother-in-law owns the adjacent property on Albert Street where the farm fronts onto Albert Street there. So I just wanted to make aware the planning department that there is possibility there for me to work with my mother-in-law and making some property adjustments in that regard. The other question that I really had was, is this archaeological assessment necessarily required if it is not indeed the Shelter Valley Creek that is within the setback of the said property, proposed property?
Madam Clerk, can you answer that for us?
Yes, through the chair. Sorry, I'm the planner. Yes, it is a water course and the checklist speaks to requiring an assessment if it's 300 meters to a water course. It's irregardless of the name of that water course. Thank
Okay,
you.
thank you. Thanks.
Okay, anybody else have any questions or comments? Virtually? Go ahead, Ms. Cole.
Thank you, Mayor Logal. I'm just recalling at one of the meetings when Lower Trent was in attendance and talking about that particular little tributary that only runs part-time of the year. I believe, is that the one that they called Grafton Creek just because it didn't have a name? I'm just putting that out there in case that is the same one. Thank you.
Thank you. We'll look into that.
Yes.
Thank
We'll
you.
look into it.
Okay. We got to what about we already talked to the applicant. We already talked to or offered it to the applicant. Okay, I'm going to read the resolution. Applications is for consent for Curtis and Liz Wilson. That applicant AH 262024 by Curtis and Liz Wilson to sever a parcel for a residential lot in part lot 11, concession 3, part 1 on 39R2626 geographically in the township of Ellenwick is approved subject to the following conditions. I think that I read that wrong. It probably should be Haldeman. That'll be fixed, I guess. Thank you. That a registered survey for the several parcel be submitted to the township. In addition to the registered survey, a geo-reference DWG file of the survey be provided in a format satisfactory to the township in Northumberland County. That a draft transfer and certificate of official for the severed parcels be submitted to the township. That the tax account for the subject property be paid up to date. Prior to any site alteration or ground disturbing activities, an archaeological assessment be carried out by an archaeological licensed under the Ontario Heritage Act and submitted by the Ministry of Citizenship and Multiculturalism. A letter issued by the Ministry of Multiculturalism indicated that the report has been entered into the Ontario Public Register of Archaeological Reports must be provided to the township and the treasurer, and the recommendations are to be implemented to the satisfactory of the Secretary Treasurer, Land Division Committee, or the Committee of Adjustments. That the applicant enter into a development agreement with the township to be registered on title of the severed parcel to secure for the completion of a grading plan at the time of submission on a building permit. That a zoning bylaw amendment be in effect for the severed and retained parcels pursuant to the Planning Act. That $12,796.34 development charges for the severed lot be paid to the township of Allen-McCulloman. That cash in lieu of parkland to be paid to the township of Allen-McCulloman at a rate of 5% of the value of the land the day before approval was granted. The value of the land is to be determined by a certified appraisal or sale price of the land, provided it occurred within 12 months of the approved date. And number 10, that $300 be paid for the issuance of a certificate of official in accordance with the bylaw 78-2024 fees and charges. Mover and a seconder. Moved by committee member Stover, seconded by committee member Ainsworth. Any further discussion? All in favor? That's carried. Next, we have application PLN 2025-25 to amend to conditions of consent AH02 2025 for Lori Bettinger. Go ahead, madam.
Thank you, through the chair. The application AH02 2025 was approved previously, and it resulted in the conditional approval for a lot addition. The applicant at the time of application was unaware that they needed to request an easement over the shared driveway that runs along the south side of the subject property. This driveway is used by the retained and benefiting property located at 226 Nickel Road to access the lands that are subject to the lot condition, or sorry, the lot addition. So the proposed amended condition will provide for an easement to facilitate that shared access. Thank you.
Thank you. Any questions from members of council? Pretty straightforward. Members of the public? The applicants? I don't see the applicant here. Anybody on screen that would like to comment on this? Pardon me.
Mayor Logo, are you able to hear me at this time?
Yes, I can.
Okay, my name is Ken Jansen. I represent both myself and my wife, as well as Lori Beitinger, who is the applicant. So I am here and present for this hearing.
I didn't catch that last little bit.
I'm sorry, I'm having a difficult time hearing you.
Okay, I'll speak up louder. How's that?
And I appreciate that. Thank you, Mayor Logo. So I am here to represent, just for clarity, we have had a survey done. It was done on April 14th. And during that survey, we learned that this shared laneway falls on both our property as well as a subject property at 230 Nickel Road. We have been using this property, that shared laneway for 10 years. I've been exclusively responsible for all the plowing, the maintenance, any type of work done on it for the last 10 years. So now, in agreement with all three parties, with myself, with the selling party, which is Lori Beitinger, and then the new purchasing owner, all three parties agree to have this this amendment done so we could share the laneway as we all benefit from it.
Appreciate. Did you have any comments on that?
No, I think it was a good description. Thank you.
Okay. Does that answer your question? I guess there was no question. You were just commenting on where you are today.
That is correct, and I do appreciate all your help.
Thank you for the comment. Anybody else online that wishes to speak? Seeing none, I'll read the resolution. It is recommended the Committee of Adjustment, the Land Division Committee of the Corporation of the Township of Alma-Haldeman enact as follows: that the conditions of consent approval AH02 2025, which conditionally approved a lot addition in lot 27, concession 6, geographically the Township of Haldeman, which was approved by the Committee of Adjustment, Land Division Committee on February 25th, 2025, be amended by adding the following condition: that a part on the reference plan be provided for the shared access between 226 Nickel Road and 230 Nickel Road, and that an easement be registered over the part in favor of 226 Nickel Road. Can I move in a second? Moved by committee member O'Neill, seconded by committee member Stover. Any discussion? All in favor? That's carried. We're going to move on to application for consent for Ludia Group Incorporated, and their application is AH04 2025. Please go ahead, madam.
Thank you. The purpose of the application is to sever a parcel for a lot addition to an unaddressed parcel on the south side of 7th Line. The benefiting lands are currently vacant. There are no buildings and structures on the lands to be severed, which are currently cash cropped. The owner did receive approval for rezoning on the proposed severed and benefiting lands, which placed the majority of the lands in a rural residential zone. The balance remained Oak Ridge's moraine countryside, which is limited to the southwest edge of the severed and benefiting lands. The related consent application, AH 45, 2016, or sorry. Yep. There was a previous consent application, AH 45, 2016, which proposed the same lot addition, which was approved. The applicant did not fulfill the conditions of consent for that application within the specified timeframe, causing the approval to lapse. The severed lot addition is proposed to be 2.15 hectares and a retained lot of 78.9 hectares. The lands are currently vacant agricultural lands that are part of a larger agricultural property with croplands, a house, and a detached garage. The southern portion of the lot is wooded and contains the evaluated McCracken Landing wetland, unevaluated wetlands, and Rice Lake tributary streams. The property has undulating topography within a drumlin in the center and southeastern corner of the lands. There is a residential lot near the corner of the south side of 7th Line, west of Highland Road, with vacant residential lots on either side. There are larger residential properties on the north side of 7th Line with cottage properties fronting Rice Lake. Lang's Resort and Wildwood Camp are to the west, and there are agricultural lands to the east and southwest. The provincial planning statement, the Oak Ridges Moraine Conservation Plan, the county's official plan, and the township's official plan consider lot line adjustments for legal and/or technical reasons. However, the adjustment must not result in the creation of a lot that is undersized for its purpose. Section 4.6 of the PPS does not permit development and site alteration on lands containing archaeological resources or areas of archaeological potential unless the resources have been conserved. Section 7.4.2 of the township's official plan indicates sites with archaeological potential shall require an assessment to be undertaken. The Ministry of Tourism, Culture, and Sports checklist with criteria for evaluating archaeological potential includes proposed development that is within 300 meters of a watercourse. The site is within 300 meters of Rice Lake, which meets the criteria for an assessment. Provided the assessment is completed, the proposal is consistent with the PPS and conforms to the county and township's official plan. The lands subject to the addition were previously zoned as noted to rural residential, and there's a portion of the proposal that is within the Oak Ridges Moraine countryside. Section 4.24, lots divided into more than one zone of zoning bylaw 19/2019 permits the portion of the lot within the Oak Ridges Moraine to be calculated as part of the minimum lot area and frontage requirements. Therefore, the proposal is in compliance with the zoning bylaw. The application was circulated to a number of departments and agencies. The Public Works Department advised that an entrance permit is required. The Building Department noted that prior to construction on the severed and benefiting parcel, a permit would be required. Northumberland County had no concerns. They noted that waste collection would be provided in accordance with their waste management bylaw, and prior to the issuance of a permit, a sewage system permit is required. Lower Trent advised that the proposed severed and benefiting lands appear to be outside of the regulated features and areas. A permit would not be required for future development on those lands. Detailed comments will be provided so they are aware of areas on the retained lands that are subject to their regulations. The Kawartha Pine Ridge District School Board reviewed the application and had no concerns. No comments were received from the balance of the circulated agencies. Notice of the application was circulated to all property owners within 60 meters of the subject lands. One resident did contact the planning department asking whether the property could be used as a warehouse. The resident was advised that the zoning would not permit a warehouse use, and should a use that is not permitted be established, the resident was advised that they can contact bylaw enforcement staff to further investigate. Establishing a use that contravenes the zoning bylaw can lead to charges under the Planning Act. The proposed lot addition is located in a rural part of the municipality within 300 meters of Rice Lake. Applicable policies permit lot additions for legal and technical reasons, and due to the proximity of Rice Lake, an archaeological assessment is recommended to be conducted prior to site alteration or development on the severed and benefiting lands. So the application is recommended for approval. We have recommended that the archaeological assessment be provided, and zoning is not required as it was done previously. Thank you.
So the, just so I understand, Tracy, the requirement for archaeological testing is only on the one side of the property?
Yes, and just to clarify in this instance, because the lot will be quite a fair size, we did recommend a development agreement because we don't know the exact limits of where they would place a house and buildings. So the development agreement will secure for that to be done because the lot is a larger sized lot in this instance. Thank you.
Thank you. Any other questions or comments from members of council? Go ahead, committee member O'Neill.
All right, thank you, Chair Lolo. It's actually, I must have been sleeping when I was reading these last week because I didn't send you the question in, but it is in fact the same question about road access for the retained parcel.
Through the chair, the retained parcel has frontage on Highland Road, and I believe it's
And that's a maintained road then?
it's maintained to the point of where the access to that property is, and beyond that limit, it's unmaintained.
Thank you.
Thank you.
Any other committee member comments? Members of the public, are there anyone that wishes to comment on this application? Seeing none in the gallery, are there any on virtually that want to speak to this? Seeing none, I'll read the resolution. Yes.
I'm just wondering if the agent is wanting to say anything on this one.
Oh,
That's my client.
can you come up to the front? Mr. Snow, come to, so we're recording, so people want to hear you.
My client who we dealt with in 2016 and had this application approved. Seen him and his lawyer, they wouldn't listen to me. I kept saying, get this registered and get on with it and get on with it. And every month I get on to them, but they got too busy that the deal lapsed. So this is why we're back here again. Yeah, so now he's going to pay attention to me. Okay, thank you.
Thank you for your comment. I'm going to read the resolution. That application AH 042025 by the Ludidia Group Incorporated to sever a parcel for a lot addition to Part Lot 18, Concession 3, Part 1 on 39R235 geographically in the Township of Allenwick is approved subject to the following conditions. That a registered survey for the severed parcels be submitted to the township, that a DWG file of the survey be provided in a format satisfactory to the township and Northumberland County, that a draft transfer for the severed parcel be submitted to the township, that the tax account for the subject property be paid up to date, that the severed parcel be deemed as a lot addition to the recipient property and the applicant's lawyer submit an undertaking to register a consolidation on title giving effect to the lot addition. That the applicant's lawyer submit a legal opinion verifying that the lot addition lands will merge on the title with the recipient parcel under the Planning Act. That the applicant enter into a development agreement with the township to secure for the completion of archaeological assessment on the severed and recipient land carried out by an archaeological study licensed, archaeological list licensed under the Ontario Heritage Act and submit to the Ministry of Citizenship and Multiculturalism a letter issued by Ministry of Citizenship and Multiculturalism indicate that the reports has been entered into the Ontario Public Register of Archaeological Reports must be provided to the township, and the recommendations are to be implemented to the satisfaction of the Secretary Treasurer, Land Division Committee, or Committee of Adjustment prior to site alteration and or development. And number 7, that $300 be paid for the issuance of a certificate of official in accordance with bylaw 782024 fees and charges. Mover and a seconder. Moved by Committee Member Stover, seconded by Committee Member Booth. Further discussion? Seeing none, all in favor? That's carried. The next one is 7-5, amendment to conditions of consent AH212023 for Louis Jenathanen, hope that's close, Agent Frank Blake, and it's amendment of condition of consent to AH212023. Tracy, please go ahead.
Thank you through the chair. Approval of application 21-2023 resulted in conditional approval for a residential lot. A copy of the severance sketch was provided. The application was approved with a condition requiring an archaeological site assessment to be prepared. That condition did not speak to the recommendations of the assessment. The assessment did focus on was done and was focused on the severed lot. The archaeologist recommended that should further development of the be proposed on the retained lot, an archaeological assessment would be required. There is a house and outbuildings on that lot. The proposed amended condition will provide for development agreement to be registered on the retained lot to secure for an assessment should future development be proposed. There is a report on the council agenda today for the rezoning application related to this. Thank you.
Thank you. Any questions or comments from members of the committee? Seeing none, any comments from the gallery or the agent that's here? Seeing none, we'll go on to see if anybody virtually has any questions or comments regarding this application. Seeing none, I'll read the resolution. It is recommended the Committee of Adjustment, Land Division Committee of the Corporation of the Township of Alma-Calderwood enact as follows. That the conditions of consent approval AH212023, which conditionally approved the creation of a rural residential lot in Part Lot 8, Concession 4, geographically in the Township of Alnwick, which was approved by the Committee of Adjustment on December 19, 2023, be amended by revising the following condition. That an archaeological site assessment be prepared by a qualified professional and submitted for review. The application must provide acknowledgement of acceptance of the assessment from the Ministry of Citizenship and Multiculturalism by adding the following words at the end of the paragraph. The recommendations are to be implemented to the satisfactory of the Secretary Treasurer, Land Division Committee or Committee of Adjustment. Can I get a mover and a seconder? Moved by Member Booth, seconded by Member Stover. Any questions or comments? All in favor? That's carried. The next one is application for consent AH012020 for Keith Bridgman. And it is PLN 2025-24, application for consent AH022020 by Keith Bridgman, the 22nd day of April 2025. Go ahead,
Okay.
Madam Treasurer.
Through the chair, application AH01-2020 by Keith Bridgman to sever a parcel of land for rural residential purposes was proposed originally in 2020 for a 0.89 hectare severed lot with a 36 hectare lot to be retained. The Land Division Committee of Adjustment first heard the application on May 28th, 2020. Staff recommended denial of that application through report 2020 PED-13, which was attached to the report. Because the property is located in the agricultural designation and residential lot creation was not permitted by the provincial policy statement, the county's official plan, and the township's official plan. All land use decisions were required to be consistent with the provincial policy statement. Council received another report, 2023 PED-07, for information which provided an update on that application. The county has begun work on updating maps and policies relating to agricultural lands as part of the county's official plan update. The applicant had requested that their property be evaluated as part of that process. The county has advised that the preliminary findings suggest there is insufficient support for an agricultural redesignation of that property. It is expected that the proposed amendment for agricultural mapping will be released by Northumberland County in the coming weeks. Public consultation will be part of that process. This report provided a discussion on the policies contained in the provincial policy statement, which came into effect on October 20th of 2024, and updated comments provided by Lower Trent Conservation Authority and the County of Northumberland. It is noted that the Planning Act Section 2 requires council to have regard for matters of provincial interest, which includes the protection of ecological systems, including natural areas, features, and functions, the protection of agricultural resources of the province, and the conservation of features of significant architectural, cultural, historical, archaeological, or scientific interest. Section 3.5 requires decisions of the municipality affecting a planning matter to be consistent with the policy statements and to conform with provincial plans. The provincial planning statement, which was updated in October, it was noted by the Lower Trent during a roadside visit of the property that there appears to be a water course within a well-defined valley system traversing the proposed severed lot. It's in their opinion that there is no building envelope available outside of the hazardous lands on that proposed severed lot. Section 4.2 water states that development and site alteration shall be restricted in or near sensitive water features, and that features and their related hydrological functions will be protected, improved, or restored. Section 4.3 agriculture states that prime agricultural areas shall be designated and protected for long-term use for agriculture. Section 4.3.3 lot creation and lot adjustment. Subsection 3 specifically states the creation of new residential lots in prime agricultural areas shall not be permitted except in accordance with policy 4.3.3.1C, which speaks to residences surplus to an agricultural operation as a result of farm consolidation. Section 4.6 states that planning authority shall not permit development and site alteration in lands containing archaeological resources or areas of archaeological potential unless significant archaeological resources have been conserved. Due to the presence of a water course within 300 meters of the proposed lot, archaeological potential should be assessed in accordance with the criteria for evaluating archaeological potential. Section 5.2 natural hazards apply to this application, but 5.2.2 states that development shall generally be directed to areas outside hazardous lands adjacent to rivers, streams, small inland lake systems that may be impacted by flooding or erosion hazards. The application is inconsistent with sections 4.2, 4.33, and 5.2 of the PPS. Archaeological potential would need to be assessed in accordance with section 4.6. Lower Trent advised that existing mapping indicates that Rice Lake tributaries traverse the northwestern and south central portions of the subject lands. There's a small area of unevaluated wetland in the south central portion of the subject property. The majority of the subject property is under agricultural cultivation with forested area in the northwest portion. Lower Trent Conservation advised that consistency with section 5.2 has not been demonstrated. Part 4 of the Conservation Authorities Act and Regulation 4124 apply specifically to 2 tributaries of Rice Lake and unevaluated wetlands that traverse the subject lands. The majority of the proposed severed lot is regulated by Lower Trent due to the presence of the watercourse and a well-defined valley system. There does not appear to be a building envelope on the proposed severed lot. There are also regulated features and areas on the proposed retained lot. Any further development on the subject property should be reviewed by Lower Trent for compliance. Any development activity within 30 meters of all wetlands or 15 meters within the stable top of bank or delineated floodplain of a watercourse, whichever is greater, any watercourse alterations and any activities that would interfere in any way with the wetlands on site would require a permit from their office. The board approved policies for the administration of the regulations state that development permitted within 6 to 15 meters of the stable top of bank of a watercourse if it has been demonstrated to the Lower Trent Conservation that the control of flooding, erosion, unstable soils, or bedrock will not be affected. The 6-meter regulatory setback is for safe access and cannot be reduced. While LTC could support development up to 6 meters of the stable top of bank, there still does not appear to be a visible building envelope. However, there appear to be others in the area on the subject land that could support a severance. Lower Trent would therefore object to the approval of the application. There does not appear to be a building envelope on the proposed severed lot outside of the watercourse's valley system and associated 6-meter setback from the stable top of bank. And detailed comments will be forwarded to the applicant. The county has reviewed the consent application and compared it to the new 2024 PPS and notes that their comments do not support approval of the application remain applicable since their initial March 2nd, 2020 comments. Despite their comments that the township's committee decides to approve the consent application, county had provided conditions to be included, which include a reference plan to be prepared that demonstrates a minimum 15-meter road widening from County Road 33, which is Merrill Road, an 18.25-meter road widening from County Road 45, and a daylight triangle across the frontage at the intersection of County Road 33 and County Road 45. They would need to submit a deposited reference plan illustrating those conditions noted in condition number 1, and they would have to deed the widenings and daylight triangle to the county. And it was noted that the township should have regard for archaeology and natural heritage features which appear to impact the proposed severed parcel. The proposed severed lot is located in the agricultural designation, and residential lot creation is not permitted by the provincial planning statement, the Northumberland County official plan, and the township's official plan. All land use planning decisions in the province are required to be consistent with the provincial planning statement, which specifically prohibits residential severances such as that proposed. The purpose of the agricultural designation is to ensure that agricultural land base is protected for agricultural purposes by permitting incompatible uses such as non-farm related residential development. There could be impacts on existing and future farm operations. Development and site alteration in or near sensitive water features and natural hazards is not supported by the provincial policy planning statement. The presence of a water course noted by LTC during the April 2025 visit indicates that the proposed lot location is not consistent with the policies found in sections 4.2 and 4.33 of the PPS. It is recommended that the application be denied for inconsistency with the PPS, the county's plan, and the township's official plan. Thank you.
Thank you, Tracy. When you were mentioning the portion regarding the Lower Trent, was that in the back in 2020, I believe you said it started? Or was that more recent?
That they had updated their comments for this application
Oh, so they had,
in 2025.
okay, so that's 2025 information.
That's correct.
Okay. Anybody have any questions or comments? Go ahead, Councillor or Deputy or Ainsworth, Mr. Ainsworth.
Thank you, Mayor. Be patient with me, Mayor. I have a few slides here that I would like to read off some comments on them. So this property has, obviously, everybody knows, been going on for 4 or 5 years to try to get severed. This property is not agricultural land. It is nothing but scrub land at the end of an agricultural field that butts up to the 5th line. So under our official plan, the rural designation is applied to lands that are of marginal value for agricultural and have potential for non-agricultural development. That's in our official plan. The county official plan indicates that creation of lots is governed by the policy of the Township of Alma-Colleman's official plan and recognizes the rural settlement areas are to be the focus of growth. The water course, supposedly water course on that property in the valley. So under regulation 4124, there's some exceptions to the rules and there's some definitions to a water course. So exceptions to the water course is an agricultural infield erosion control structures that are not within and that do not have any outlet of water directed or connected to a water course, wetland, or river, stream, or valley. So literally that's a runoff that comes down through the valley from that field to the south of this lot, and it goes under a culvert of the 5th line and goes into another farmer's field, and that's it. If that course can get to Rice Lake, it'd be nothing short of a miracle, because it would have to probably go 200 feet uphill and a couple kilometers away. And so I went out to that property on Sunday, and there is actually no water running in that valley right now. So the definition of a water course under regulation 41/2024, water course means a defined channel having a bed and banks or sides in which the flow of water regularly or continually occurs. So there's nothing there right now. And it's like, again, it's nothing but a runoff. I took some pictures and I obviously can't share that with council, but there's nothing there in that. So back in 2020, Lower Trent Conservation has identified the Lower Trent regulated lands, which include the water course and associated setbacks, as well as unevaluated wetlands on the subject property. The proposed severed lot is located outside the Lower Trent Conservation regulated lands. So I don't know why that changed in the last couple of weeks. And so
Are you taking that from where are you getting your information?
well, this is right off our official plans. It's right off the 2020. That part is also in our report here. right? So that's because that came back from the council that was previous in 2020.
Yeah.
So that whole report is in there, and that's what I'm reading off in the 2020 report. A couple of other things, so the Lower Trent Conservation thing, you know, even though I sit on the board, there's just no way that that's a contributory to Rice Lake. You walk out there right now and there's literally nothing there. So they talked about the Public Works having an issue with it, but at the time in 2020, Public Works confirmed that the entrance, which is already there to the property, it's proposed to sever that lot can be granted from the fifth line at a location to be approved by the Public Works manager. But there's already a laneway there. And as discussed earlier, Lower Trent Conservation reviewed the application and has no objection to the proposed severance. However, they did identify regulated lands in the property, which was the stream. But under Regulation 4124, that is not a stream, nor it is a contributory. And I wish we could get that straightened out because it's happened a few times. I want to address the county piece on this property. So I don't know where the county is coming from when they talk about a minimum road widening of 15 meters from the painted center line of County Road 33 on Merrill Road along the frontage of the retained parcel. A minimum of road widening of 18.25 meters from the painted center line of County Road 45. So this lot is probably 1.5 kilometers from 45. It's not even on 45 and it's not even on 33. It's on the fifth line. So all that stuff that the county is talking about should just be wiped right out of this report because it has nothing to do with that piece of property. So again, and I want to go back to, and I know the planner commented on this with Deputy Mayor Stover, but the way it's written up does not clarify the way that it's being explained. So the dwelling at 12699 County Road 24 was severed from a 20 hectare agricultural property and was rezoned rural residential. So however you want to say that piece right there is telling me that we took agricultural land and rezoned it rural residential in 2020. And that was farmland. This is scrubland that we're talking about for the Bridgemans. So I want to go to a letter that was sent to us. I believe it didn't get circulated, and if it did, I apologize. But this was back in 2020 that a letter came to staff and it came from David Piccini because the Bridgemans have been reaching out to our MPP and also reaching out to Doug Ford. So a letter from David Piccini dated November 20th, 2023. It was written in regards to a request from myself, is information pertaining to the request for property redesignation on 50 Merrill Road. And they talk about the residents, Tammy and Carrie Bridgman, have been trying to almost for 4 years to have a small parcel of severed lots for their son to build a home. In today's housing crisis, this is stories like these in the rural communities like ours that are so often heard. And this is MPP Piccini's words. And I won't read the whole thing, but at the bottom part, it says the lower tier municipality council have the authority to request to fully support a land use redesignation. This has been done in a number of occasions in other regions I have served through the land reclassification process established by the upper tier, usually involving a soil classification study. So we have that. And then back in March of 14th, we had a meeting at MPP's office in Port Hope with David Piccini and Dwayne Campbell. And Dwayne Campbell sent this email off to a few of us and also our planner. And I will just read his message. So earlier today, I communicated this matter with Minister Piccini and Councillor Ainsworth. Additionally, I clarified that while there is likely no land use justification for the change from the agricultural designation, the Township of Alma-Colborne Committee holds the final authority on matters of lot severances. Should the committee choose to approve a severance despite the land use considerations, county planning will respect and adhere to the committee's decision. So their comment is that if we make the decision to do it, they're okay with it, regardless of what all this other stuff says. So that's kind of my background on how this has all been taken and how it's all come to be. And I think most of us has gone out and seen that property, and we can all say that it's agricultural property. It's nothing but scrubland. They want to use that property to make a home for their son and his wife and child. And back in 2020, they were under the assumption that this was going to get passed. So the son sold his house and everything and thoughts that this was going to get prepared to get this lot severed and get it all ready for them to build a new home. And here we are almost 5 years later, and it hasn't been done. So, you know, we can pass this today with all this information and background and understand that we have the power to make that designation. And no one's going to slap our hands, especially not the province. Thank you.
Anybody have any comments? Go ahead, Councillor. Committee Member Booth.
Through you, your worship. I feel for this applicant, the Bridgemans. This came to previous council. And at that time, I was one of the council members that, because we were told that the county was looking at redoing the mapping and that they would look at this, because Councillor Ainsworth is correct. When you go out there and look at this, this is not agricultural land. It's scrubland, trees, bushes, that's it. There's no crops growing on there or anything. So I was under the understanding that they would have a very good chance that the county would redo the mapping. But according to what we're hearing here is they're saying that the county has advised that the preliminary findings suggest that there is insufficient support for an agricultural redesignation. I don't get that. I don't understand why they just can't look at that and go out and look at the property and say it was a mistake that it was ever. So, you know, I'm looking at all of this now and I feel for them because, and as Councillor Ainsworth said, I mean, I'm changing the way that I'm looking at this now as they've tried everything with the county and that, and they're getting nowhere. So I would be in favor of this. Thank you.
Go ahead, Committee Member Stover.
Thank you, Mayor Logal. I just, if I may, ask the planner about the building envelope and the chances of getting, the Bridgemans getting a building permit, should this be successful today? That would be the question I would like to propose to our planner, if I may.
Thank you. Tracy, would you mind answering that?
Yes, through the chair, I would suggest that if council were to consider this, that they apply a condition to make sure there's a suitable building envelope outside of the regulated area. It could be a condition. I wouldn't recommend. Obviously, I haven't recommended approval, but if that were the case, I would like to see that the decision is backed up by some sort of criteria so that other people who have agriculturally designated properties aren't coming knocking on the door looking for similar applications. Thank you.
You have a follow-up?
Just a follow-up, Mayor Logal, if I may, and it would have to do with a limited building area. I would just like to ask our planner if she would have any idea of the size of a house that could be built on here, because if my concern is that if they can't get the building permit, they're going to be putting a lot of money forward to this property where the envelope is not going to allow any building other than maybe a shed. If I may propose that question to the planner, I would like to do so.
Tracy, can you answer that?
Through the chair, on the attachment shown with the report, there's a large area that they have, there's a specified distance around a water course. So I would think that the envelope would have to be picked up and moved to another location to be located outside of that regulated area. The comments from LTC noted there's other areas on the property that are not impacted by the regulated area that could be looked at.
Thank you.
Go ahead, Member Ainsworth.
Through you, Mayor. So again, if I go back to the regulation 4124 that has the definition of a stream or a water course, this doesn't meet it. I don't know why we're not like why that can't be put in the report. I mean, you can say that it's a contributory to something, but it's a runoff from the field. There's nothing there right now. So I don't even understand, like, and sure, I can go back to Lower Trent Conservation and bring this up and say, hey, you need to reevaluate that property because it's evaluated wrong. 100% it's evaluated wrong. There's no way that's getting to Rice Lake. It didn't even get enough water on the runoff when it ran through the culvert into the other guy's field to even create any kind of a trench. So I understand that it says it's regulated, but it's wrong. And Lower Trent will probably be the first one to say that their policies and their mapping is not up to date.
It's too bad they couldn't have said that in the last 4 years, but.
Well, they are. They've said it to us.
Oh, have they?
Well, I've gone down a couple other times about different things and they're not. And they're, it's just that they're short staffed and they're trying their best.
Go ahead, Member O'Neill.
Okay, so first and foremost, when we look at our community and what they want, protection of farmland comes right at the very top. And there's only so much farmland that manages to get the designation. We already saw a piece of property this morning that is being used for agriculture, but it doesn't have the designation of agriculture on that piece of property, so that land is not protected. People want farmland protected. That includes farmers. Farmers want farmland protected. And this is just, in my mind, the opening of a door to every agricultural piece of property to have a severance made on it, because every single piece of agricultural land is going to have some corner on that piece of property that it isn't perfect for farm use. This is not, in my mind, the precedent we want to do. I do not want to see our planner being inundated with people saying, well, wait a minute, here's my exception. Wait a minute, here's my exception. And I'm also concerned about some of the things where we have council or members of council indicating that they want to make these judgment calls rather than leaving these judgment calls to the professionals who've done it. So on both of those, I think protection of farmland is something that is wanted by our residents, is wanted by the agricultural community. And my second is that we need to respect the professionals who've made these designations.
Thank you. Go ahead.
Do you, Merritt? I too respect the agricultural land. And this is not agricultural land. And if another farmer's got a piece of land that he wants to sever off for his son, that's not agricultural land, that's designated agricultural, he should be able to do it. And us as councillors in the township, we should be respecting that and working with our residents to make that happen. They could get a second dwelling put in right in the middle of that big field. This is how crazy this is. You could get a second dwelling put right in the middle of that plowed field to the south of them, and that's okay. But they can't take that piece that's all wooded and make a lot of it. So that's how ridiculous it is.
Thank you. Go ahead.
Through your Mayor Logal, and
Over.
thank you. It's just basically a comment on the county looking at these properties, and they're not, and we're asking the county to look at specific properties, Mayor Logal, but they aren't doing that. They're still looking at mass properties, and this is one of the problems we have, that they know this exists, but they are not taking the time to look at this specifically. Thank you.
That's a good, excuse me, that's a good point. They look at sections rather than
Acreages.
acreages.
Mhm.
Go ahead, Councillor Member Booth.
Through you, your worship, just to the point of what Councillor Ainsworth said about the LTC, then is it possible, since you're a member of them, could we defer this or something so you can go back to them? I'm talking now about this supposed water course that there seemed to be no issue in 2020. Now all of a sudden it's come up. Could you take that to them and have somebody come out and actually take a look at it and come back to us and report, is this actually a water course or is this just a runoff? Because I know we've spoke about it. I have the same thing in the spring where sometimes if the snow melts too fast, it runs down there and then, 11 and a half months out of the year, there's nothing there. So I'm just wondering, would that be acceptable that we could defer this and you can go back to them? At least we can clear that part up.
Through you, Mayor, if I can.
Yep.
So I think at this point, Councillor Booth, that it's probably not going to make a difference on where the severance is going to be. That's probably only going to be the difference on the archaeological assessment. If that makes sense, because the building envelope is about 30 feet higher than that ravine. And where the survey stakes are going to be, there's a telephone pole kind of right there. And it literally goes along the ridge of the building envelope. I don't think the ravine is going to be part of that. But because it's within that 6 or 15 or 30 meters, that's the classification of it.
Go ahead, follow up.
Through you, Your Worship. So just a comment, maybe I'm misunderstanding, then maybe the planner could explain it. That river course that's supposedly in there, is that affecting just the archaeological study, or is it actually affecting the location of where the building can go to? I thought it was both.
Through the chair, it would affect the building envelope. There are other water courses in proximity to the property, so it's not that specific water course that would be the only trigger for the assessment. There are other water courses. There's one on by County Road 45, and there's one further to the west. So it would be more of an impact for the location of the envelope in proximity to a regulated area.
Okay, so through your worship, that's where I'm going at, Councillor Ainsworth, is it's affecting two things then. As the deputy mayor stated, where the location of the building envelope can be, and also whether or not, so I don't think that's going to affect the archaeological because they're going to use other waterways there, but I'm more concerned about this person's going to go through all of this and find out that they can only build a 10-by-6 shed because to keep them away from the, all the setbacks that they have to do.
Go ahead.
That, through you, Mayor, oh, was it me?
Yes, it was. No.
Thank you, Mayor Logal. That is my main concern here. And I hate to say defer, but this building envelope, I think, is going to cause them problems. And that's my only concern here. Thank you.
Go ahead.
Mayor, we have, through you, Mayor, we have had applications come here where we've made the footprint smaller on lots. We've moved through minor variances. We've moved property lines so they could put different sizes of houses in, septic tanks in. And I don't see any reason why we can't do stuff like that here with this one.
Okay.
If the footprint really is a problem, it's a fair sized piece of land.
Have you had an opportunity to look at that, Tracy? And who makes that decision? Footprint.
Through the chair, I think, well, the footprint is tied to a number of different things, but I did have a suggestion, if that's okay.
Yes.
There could be a condition that states that the severed lot limits be located to provide a suitable envelope outside of the regulated areas. So that way there's some flexibility. Thank you.
And is that necessarily in where it is now? That could be any place?
Yeah, they could adjust the location. The size would be, as long as the size is consistent with the application, I think that would be appropriate.
Thank you.
Well, I don't think that would be
Yeah,
appropriate because of the other policy considerations. I can't make a recommendation based on the policy requirements.
Thank you.
You're welcome.
Councillor, or pardon me, Committee Member O'Neill.
I just am very uncomfortable with overriding professional advice. B, these people are a squeaky wheel, and they have a member of council who's elevating their concerns. But we have had so much staff time, our staff time, the county staff time, Lower Trent's time spent on something where they have been told no. They've been told no several times. They've also been told that they do in fact have the option of a second unit on there that can be built without the severance being done. They have options. I do not think that the only option that we want is to make this exception and open the door for every other farm in our township to say, this little corner of my property isn't very good, so I want a severance. And this little corner over here isn't very good. And all of a sudden, we, instead of doing what our official plan says and concentrating development in our hamlets, we are going to have our entire time of our planning department looking at exception after exception after exception. And then we're going to bring it back and bring it back and bring it back. There are other people who've been told no, who just accepted the no and moved on with their life and made another plan.
Go ahead.
Through you, Mayor. So I'd like to ask Councillor O'Neill, like, do you want to raise taxes or build houses?
I want us to have, sorry,
Yep. Thank you.
Thank you.
Would you like that answered?
No?
Okay. I've got you,
Um,
Tracy.
Through the chair, just to help with some clarification, if this application happened to be approved and others come to the counter asking for severances on agricultural properties, I won't be looking at criteria because the provincial planning statement is very clear in that agriculturally designated properties are not permitted to have lot severances for residential purposes. So I just wanted to make sure that that would be clear.
Thank you. Go ahead.
through you, Chair Logan.
Thank you.
To that, I mean, in theory, that's exactly what our planner has already done. Our planner has already clearly told these people and told council and through this report, telling us again today, this does not meet the provincial policy statement and we should follow it or whatever it's called right now. To the other, I do want to reiterate, I want to see housing built exactly where we say it is to be built in our official plan, which is concentrated in our hamlets.
Thank you. Anybody else have anything? I'm going to throw in my 2 cents worth. This has gone on for a long time, and I agree with Member O'Neill that it's taken an awful lot of time. And I think it really goes back to the problem was when the person first went ahead and paid for his, I'm sure he paid for his application. But he did that too quickly. And should have got permission to, or the permits filled out and everything else. But how long do you want to keep this on for? Because it's never going to go away, I don't think. So, you know, it's a little tough, but I think we got to make a decision. Go ahead.
Through you, Mayor Logal, and if I may just make another comment, through other properties that have come forward, I have heard the word marginally value agricultural land. And that is what I look at when I think of that property. Thank you.
Okay, good point.
Thank you.
You're suggesting anything?
No.
Okay, go ahead.
Through you, Mayor. So I'm suggesting that, you know, we take a vote on this, but I think the planner has given us a couple of options on the footprint that her and the applicant could work out
Thank you.
once passed.
Anybody else have any comments? Do you want to make a motion then?
Yes, I would make a motion that we pass this. without the exceptions of the county part of the report.
And aren't you also asking that the applicant and the planner get together and
Yes. And I just figured that would happen naturally,
uh,
but I'll make it, so I'll make a motion that we accept this application with the conditions that the applicant sits down with the planner and it works out the footprints for development. And I guess I just want to, also, if we could put it in the motion or whether I need to, but I can talk to Lower Trent and maybe get someone out there to figure out what's going on with the little runoff.
that's what you're suggesting. Have you seen this?
Through the chair.
Yes.
In it, I had prepared some conditions in the hopefully off chance that this was going to be approved. But there's a copy there for you if you would like to consider those.
Okay.
Planner. And are we in a position where this property size could be expanded? May I ask that to the planner? Just to incorporate a big enough building envelope. Secondly, if it is to be expanded, then you're looking at new severances.
Looking at what you mean.
A bigger, not severances, but surveys.
I don't,
Through the chair. So the applicant wouldn't have done a survey at this point. Usually that's done after an approval.
Oh, okay,
Um,
good.
So a condition could be worded to provide some flexibility. I had prepared some conditions that maybe we could look at revising. There's a number 7. Would you like me to read the whole document out for the committee?
sure.
Okay. Um, so should this application be proposed for approval, the following conditions would be appropriate. To submit a draft reference plan at the applicant's expense, which illustrates the following. A minimum road widening of 15 meters from the painted center line of County Road 33, Merrill Road, along the frontage of the retained parcel. A minimum road widening of 18.25 meters from the painted center line of County Road 45 along the frontage of the retained parcel, and a daylight triangle across the frontages at the intersection northwest corner of County Road 33 and County Road 45. Number 2, that a registered survey for the severed parcel be submitted to the township and the county, which illustrates the above requirements under condition 1. Number 3, in addition to the registered survey, a georeferenced DWG file of the survey be provided in a format satisfactory to the township and the county. Number 4, to deed the road widenings and daylight triangle to the county of Northumberland at their expense, and that the deeded lands are free and clear of all encumbrances. Number 5, that a draft transfer and certificate of official for the severed parcels and road widening be submitted to the township. Number 6, that the tax account for the subject property be paid up to date. Number 7, that the severed lot limits be relocated to provide a suitable building envelope outside of the areas regulated by the Lower Trent Conservation Authority pursuant to Part 6 of the Conservation Authorities Act and Ontario Regulation 41-24, including the 6-meter setback from the stable top of bank of a valley. Number 8, prior to any site alteration or ground disturbance activities, an archaeological assessment be carried out by an archaeologist licensed under the Ontario Heritage Act and submitted to the Ministry of Citizenship and Multiculturalism, MCM, a letter issued by MCM indicating that the reports have been entered into the Ontario Public Register of Archaeological Reports and must be provided to the township, and the recommendations are to be implemented to the satisfaction of the Secretary Treasurer, Land Division / Committee of Adjustment. Number 9, that a zoning bylaw amendment be in effect for the severed parcel, subject to application, and I have a typo in there, AH01 2020. Pursuant to the Planning Act. Number 10, that $12,796.34 development charge for the severed lot be paid to the township of Alma-Calderman. Number 11, that cash in lieu of parkland to be paid to the township of Alma-Calderman for the severed parcel at a rate of 5% of the value of the land the day before approval was granted. The value of the land is to be determined by certified appraisal or sale price of the land, provided it occurred within 12 months of the approval date. Number 12, that $300 be paid for the issuance of the certificate of official in accordance with bylaw 78-2024 fees and charges. Thank you.
Yeah, I am mayor. I just want to question the road widening and stuff for this lot, because there's already people living on the road. There's a house on the corner. There's a house right beside the lot that's going to be severed. And I know just some clarification why that has to be done when there's already people living there. And the triangle signage and stuff like that. So other than that, I'm okay with the rest of the stuff. Thank you.
Through the chair, it's typical that road windings are asked for through Planning Act applications. We saw that in the previous application where the Hogs had been required to give a road widening along the severed and retained parcels. It's the time where the jurisdiction of the road has the ability to ask for it. The daylight site triangle is very important to secure for sight lines at the corner of a very awkward intersection. And I would suggest that those recommendations stand. Thank you.
Mayor Logal, I just would like to have the Madam Planner refresh my memory on the condition dealing with the Lower Trent, if I may.
Through the chair, it's written to say that the severed lot limits be relocated to provide a suitable building envelope outside of the areas regulated by Lower Trent Conservation Authority pursuant to Part 6 of the Conservation Authorities Act and Ontario Regulation 41-24, including a 6-meter setback from the stable top of bank of the valley. That condition would give us the opportunity to have conversations. We would sort out the location of the lot limits outside of the regulated area, so we could have conversations with Lower Trent staff, the applicant, and myself to determine the location.
And
thank you.
If I may, the meeting minutes that accompany this meeting today, would they also include the mention of Member Pacini being involved in this as well, knowing this as well as the Mr. Campbell from the county? The reason I say that is I don't want them thinking that we're sneaky and not doing anything, that they are aware of this.
Through the chair, they have been noted in the minutes. Yes.
Thank you so much.
You're welcome.
Through you, your worship, I'd like to say that's a very good report you just gave us, Tracy. Thank you. That to me, because I see two different things here, whether or not this person can get that severance because we're considering it's farmland. And that one I've made my decision on, but just because in my mind we give them that doesn't mean that they don't have to follow the rules of everybody else. And for example, what you said, the hogs that just was okayed by us, they had to fulfill those things with the roadway. So I don't think that the Bridgemans get excluded from everything. And I like that you did. It seems like it's a saw off that we're willing to do something, but that the Bridgemans still have to meet all these other conditions and the concern about whether or not where they're building and things like that. So I like that. Thank you very much.
Are you prepared to second the motion?
Yes, I do.
Any further discussion? Okay, I'm going to read the motion just so everybody's clear on it. That application AH 012020 by Keith Bridgman to sever a parcel for the creation of the rural residential lot in part of Lot 18 Concession 4 geographically in Elmwick is approved subject to the following conditions. To submit a draft 39R reference plan at the applicant's expense, which illustrates the following. A minimum road widening of 15 meters from the painted center line of County Road 33 Merrill Road along the frontage of the retained parcel. A minimum road widening of 18.25 meters from the painted center line of County Road 2045 along the frontage of the retained parcel, and a daylight triangle across the frontage at the intersection northwest corner of County Road 33 and County Road 45. That a registered survey for the severed parcel be submitted to the township and the county, which illustrates the above noted requirements under condition 1. In addition to the registered survey, a georeference DWG file of the survey be provided in a format satisfactory to the township in Northumberland County. Number 4, to deed the road widening and daylight triangle to the county of Northumberland at their expense, and that the deeded lands are free and clear of all encumbrances. 5, that a draft transfer and certificate of official for the severed parcels and road widening be submitted to the township. That the tax account for the subject property be paid in up to date. That the several lot limits be relocated to provide a suitable building envelope outside of the areas regulated by the Lower Trent Conservation Authority pursuant to Part 6 of the Conservation Authority Act and Ontario Regulation 41/24, including a 6-meter setback from the stable top of a bank or valley. 8, prior to the site alteration or ground disturbing activities, an archaeological assessment be carried out by an archaeological license under the Ontario Heritage Act and submitted to the Ministry of Citizenship and Multiculturalism. Letters issued by the Ministry of Citizenship and Multiculturalism indicates that the reports has been entered into the Ontario Public Register of Archaeological Reports must be provided to the township, and the recommendations are to be implemented to the satisfaction of the Secretary Treasurer of the Land Division Committee of the Committee of Adjustment. That a zoning bylaw amendment be in effect for the severed parcel subject to applicant AH 252024 pursuant to the Planning Act. The $12,796.34 of development charges for the severed lots be paid to the Township of Allen-McAlderman. The cash in lieu of parkland be paid to the Township of Allen-McAlderman for severed parcel at a rate of 5% of the value of the land the day before approval was granted. The value of the land is to be determined by a certified appraiser of sale price of the land provided it occurred within 12 months of the approved date. And number 12, that $300 be paid for the issuance of the certificate of official in accordance with bylaw 782024 fees and charges. All in favor? The motion is carried.
Sorry, Mayor,
Yes.
it is at this point a recommendation, correct?
No.
We're still in committee, right? This would have to come back as a motion? No, could I ask for,
Yeah, we've made the decision.
sorry, in that case, could I ask for a recorded vote, please?
Mayor Logal, I believe the vote has already happened.
Yes, and they can ask for one before or after.
Oh, is that right?
Yes,
Thank you.
I'm pretty sure it is, isn't it? I'll have to check that. I thought you could, I thought. The meeting was before or after.
Sorry, I was trying to catch your eye there.
Before or after.
Thank you.
So if you ask for a recorded vote, then we'll take a recorded vote. After you read it, but I'm pretty sure that's what it says. Well, do you want to take the recorded vote? Alex?
Is it allowed?
Yes. Before and after, page, whatever it is, it's number
26.
13.7 on page 26 of 49. 13.7.
Immediately
Before or
before,
after.
after the taking of a vote.
You're going to call out the names, okay?
Committee member Ainsworth,
Yes.
committee member Booth,
Yes.
committee member Local,
Yes,
committee member O'Neill,
No,
committee member Stover,
Yes.
thank you. I'm going to suggest we take, well, we'll finish this up and then we'll take a 10-minute break. Motion to adjourn is recommended that the Town Committee of Adjustment, Land Division Committee of the Corporation of the Township of Alma-Cullivan enact as follows. The Committee of Adjustment, Land Division Committee meeting held on April 22nd, 2025 be adjourned at 11:41 a.m. Mover and seconder. Moved by your hand. Moved by Councillor, Committee Member Booth and seconded by Committee Member Ainsworth. All in favor? That's carried. So we'll just go, can we go right over there? I'll 10-minute break. Oh, okay. Yeah, we'll take a 10-minute break and then we'll reconvene at approximately. Okay, we're going to reconvene. Are you ready to start? Like go. We're going to reconvene to our municipal planning / regular council meeting. So I'll take a motion that the committee of the council of the township of Alma-Cullivan, being a land division committee or committee of adjustment, reconvene to the municipal planning regular council meeting at 11:50 a.m. Mover and seconder. Moved by Deputy Mayor Stover, seconded by Councillor O'Neill. All in favor? Motion's carried. We need a motion to go into a public meeting. It is recommended the council of the corporation of the township of Alma-Cullivan enact as follows. The council go into a public meeting under section 34 of the Planning Act at 11:51. If I can move in a second. Moved by Councillor Ainsworth, seconded by Councillor O'Neill. All in favor? That motion is carried. We have a zoning bylaw amendment application for Gail Dijon. That is PLN 2025 zoning bylaw amendment application for Gail, this 22nd day of April 2025. Do you have anything you want to add to this? Tracy?
I think like if you want me to go through the report, I could.
I don't think
Maybe
that's
just for the benefit of anyone who may be wanting it to speak to the application from the public,
okay.
I'll just do a high-level overview.
Okay,
The application was submitted to address a mobile home that was installed on the property. The agent has requested approval of a garden suite to be located at 910 County Road 22. The applicant, or the agent is Marge DeYoung, and the property is owned by her sister-in-law, not sister, which was noted in the background, Gail DeYoung. So the Planning Act does allow for the establishment of a temporary use for a garden suite, and we can enter into an agreement for that garden suite to outline the terms for the installation and use, the period of occupancy, and any monetary or other form of security required for the costs related to that garden suite. There is a bylaw later in the agenda for authorizing an agreement. The property is in the Oak Ridges Moraine. However, it does recognize the permission for existing single detached dwellings along with accessory uses. A garden suite is considered ancillary use, which is similar to accessory, so it was considered to be permitted. The requirement is for a zoning bylaw amendment to address the permission for that garden suite. And there'd be an exception to that section did limit the section 4.14.2A of the zoning bylaw limits garden suites to rural residential, rural and agricultural zones. And since there's no policy or legislative direction to restrict garden suites to specific areas, an exemption is appropriate. So we are recommending approval of the application, and it would be for a period of 20 years. Thank you.
thank you, Tracy. Any questions or comments from members? Go ahead. Councilor O'Neill.
Just a comment that I think the use of garden suites, that it is Alnwick Haldeman having this already built into our official plan. And they are excellent and we should be doing more of it. And it does contribute to providing housing in a temporary manner, which is great at either end of the spectrum when you're trying to get in the housing market or you're leaving the housing market. But overall, this is excellent. And I'd like to see it used more to bring several of the trailers that are already out there into compliance and safety. So excellent. Pleased to see this.
Thank you. Other comments? All in favor?
Oh, hang on. Are there people online? This is a public meeting.
Okay. Members of the public, do you have any questions or comments? Seeing none in the room, how about on the virtually? Anybody would like to comment? Seeing none, all in favor? I made a mistake. We're not voting on that yet. We got to wait till we get to the bylaw. This is just an explanation. So I apologize for that. We'll move on to zoning bylaw amendment application 1409673 Canada. And it's for Louis J. Anathan. Tracy, go ahead.
Okay, thank you. This is a public meeting as well. The Committee of Adjustment approved application AH 21-2023 for the creation of a 0.405 hectare lot, retaining a 5.66 hectare lot with a house and accessory buildings. There was an archaeological site assessment prepared as required by the conditions of approval, which were amended in the previous meeting this morning. Based on the recommendations of the stage 1 and 2 archaeologist, a development agreement is necessary to secure for an assessment on the retained lands should future development be proposed. A bylaw is included in the agenda to authorize the mayor and clerk to execute the development agreement. The proposal is consistent with the provincial planning statement, the county's official plan, and the township's official plan. The zoning bylaw amendment will rezone the proposed severed lot to rural residential. There were no significant comments aside from what had already been provided through the consent application. And we are recommending approval, and there is a zoning bylaw amendment further in the agenda. Thank you.
Thank you, Madam Planner. Any members of the public that want to comment on this? Seeing none in the gallery, we'll also ask, see if anyone on virtually want to make a comment. Seeing none, we'll move on to item 10.4, which is a motion to reconvene to a municipal planning / regular council meeting. It is recommended the council of the township of Alma-Calderman enact as follows: that the council of the township of Alma-Calderman reconvene to the municipal planning regular council meeting at 11:57 a.m. Are you moving to second? Moved by Councillor Booth, seconded by Councillor Ainsworth. All in favor? That's carried. We're going to move on to 11, which is the planning bylaws. Bylaw number 32025, zoning bylaw amendment Z022025. It is recommended the council of the corporation of the township of Alma-Calderman enact as follows: the bylaw number 32025 being a bylaw to amend bylaw 192019, the comprehensive zoning bylaw, be given a first, second, and third reading and finally pass this 22nd day of April 2025. Moving to seconder. Moved by Councillor Ainsworth, second by Deputy Mayor Stover. Any questions or comments? All in favor? Motion is carried. Next one is bylaw 312025, zoning bylaw amendment Z032025. It is recommended the council of the corporation of the township of Alma-Calderman enact as follows: that bylaw 312025 being a bylaw to amend bylaw 192019, the comprehensive zoning bylaw, be given a first, second, and third reading and finally pass this 22nd day of April 2025. Do I get moving a seconder? Moved by Councillor Ainsworth. Second by Councillor Booth. Discussion? Tracy, do you have a comment?
Through the mayor, you had asked a question about the costs associated with moving the garden suite should the municipality have to do so. I have a proposed revision to the schedule for the agreement. If you would like, I can bring that up.
Yep. Everybody asked, answered, or you know what I'm talking about?
Oh. This is 31 that we're on. It was bylaw 32. Apologies.
Okay. This is for 32. Okay, more than that. And then we're bringing this next. We're on course. All in favor? Motion carried. I have an addition to the
Sorry, it's not 32.
addition to the agenda.
Which one is? No, is it? It is 32. 33.
Next point is bylaw 32-2025. To execute a development agreement with 1409673 Canada. It is recommended that the Council Corporation of the County of Alma act as follows. That bylaw 32-2025 being a bylaw to authorize the execution of a development agreement with 1409673 Canada Incorporated. Be given a first, second, and third reading and finally passed to the 22nd day of April 2025. Mover and second. Moved by Councilor Ainsworth, second by Deputy Mayor Stover. Any questions? All in favor? Motion is carried. Then we're going on to number 33. And Tracy, do you have a comment on this one?
Yes, thank you, Mayor. Through you. There was a question over the weekend about the costs associated with removal of the garden suite. So I have provided alternate wording for number 2 on Schedule A. Right now it reads, if within the times provided in paragraph 1B of this agreement, the owners have not removed the garden suite, the municipality shall have full right of access to the property for the purpose of removing the garden suite. And the question was about the costs associated with that. So I did look up some alternate wording. It could be replaced with the following. In the event that the owner and occupant fail to remove the garden suite from the subject lands in accordance with the provisions of this agreement, the municipality may enter upon the subject lands to remove the garden suite, and all costs incurred by the municipality in connection therewith shall be recoverable from the owner pursuant to the provisions of Section 326 of the Municipal Act, CM 45 RSO 1990 as amended, whereby the costs incurred will be added to the tax roll and collected in a like manner as taxes. So that provision would enable the municipality to go in and recover the costs if the owner doesn't remove the garden suite at the end of the 20-year period or are successful in asking for an extension to that temporary use. Thank you.
Thank you, Tracy. And Emily. So Emily is telling me that what I should do is read the original motion, and then we'll add on what Tracy has suggested we put on. Yeah.
So through you, Mr. Mayor, at our planner's recommendation with the requests that come through for the inclusion of a provision on how to recoup cost, if council is looking to add that to the bylaw as it's presented, I would recommend at this point as a matter of procedure that you would get that moved and seconded on that clause that our planner just read to amend the bylaw. And then at that point, you would move on to your second course of business, which would be to approve the bylaw as amended.
First of all, we got to get a mover and a seconder to accept Tracy's presentation, and we'll amendment. So I need a motion to approve the amendment as suggested by our planner. So I'll take a motion for that, moved by Councillor Booth, seconded by Councillor O'Neill. Any questions? Councillor Booth.
Through your worship, just that's going to then be added to this agreement, right, that talks about if the occupant's not there anymore and things like that, right? Because you had mentioned the reasons why, but not the number one in here that talks about if that person is passed away or that.
Yes, correct. So it would simply replace number 2 with the statement that I read. So
Yeah.
the balance of the agreement would remain in place.
Thank you. Yep,
Thank
that
you.
makes sense. Yes.
Okay, I'll read the amended bylaw. Not yet, I'm getting closer. Well, I'll read this one first. So, amendment. So bylaw number 33-2025 to authorize an agreement for a temporary use garden suite. And in order to recoup the costs, we'd like to amend to replace clause number 2 with in the event that the owner and occupant fail to remove the garden suite from the subject lands according to provisions of the agreement, the municipality may enter upon the subject lands to remove the garden suite, and all costs incurred by the municipality in connection therewith shall be recoverable from the owners pursuant to the provisions of section 326 of the Municipal Act, CM 45 RSO 1990 as amended, whereby the cost incurred will be added to the tax roll and collected in a like manner as taxes. So the bylaw states that bylaw number 33-2025 being a bylaw to authorize an agreement for a temporary use garden suite be given a first, second, and third reading and finally pass this 22nd day of April 2005, including the replacement of paragraph 2. What were you going to suggest? Okay. Okay, call them. Okay, first I need to call the vote on the amendment. All in favor? Carried. No, you want me to? No. Okay. It is recommended the Council of the Corporation of the Township of Alma-Haldeman enact as follows: that bylaw number 33-2025 being a bylaw to authorize an agreement for a temporary use garden suite Dijon be given a first, second, and third reading and finally pass this 22nd day of April 2025. Could I get a mover and a seconder? Moved by Councillor Ainsworth, seconded by Councillor Booth. Any further discussion? All in favor? That's carried. Thank you for being here. Okay, we're moving to adjourn. Move to adjourn to a land division. My other one. Oh, okay. We've already done that. Next, we're going to 13 to authorize agreement of no, yes. 13.3 is bylaw number 34-2025 to authorize agreement with Northumberland County for GIS services. Bylaw 34-2025 to authorize agreement with Northumberland County for GIS services. That bylaw 34-2025 being a bylaw to authorize an agreement with Northumberland County for GIS services be given a first, second, and third reading and finally pass this 22nd day of April 2025. Could I get a mover and seconder? Moved by Councillor O'Neill, seconded by Councillor Ainsworth. Any discussion? Go ahead. Mike?
Through you, Mayor. I just had a couple of questions just because of the cost of this, and I'm wondering if because I think quick calculations for me, it's about almost $46,000 a year for us, and that's not counting the fully loaded cost.
Not counting who?
Not counting the fully loaded costs.
Okay.
So I looked at it. To me,
Tracy, clarify that. Can you do that, Tracy, or no? Or you need some time?
Through the mayor, the expected cost is $23,145. It's noted under section 3.3 on page 8 of the agreement. And we did put that amount in the budget that was approved by council this year.
Okay.
Thank you.
Does that answer your question, Mike?
Well, yes and no.
Okay.
Only because it's the cost, because there's like a monthly cost of $1,412. It's an annual cost of $23,145. And that comes to 40,000. And then you got the hosting data, the finances services, the development license, that's another almost $5,000 in the total cost. And then you add in all those fully loaded costs that for their wages and their benefits and their overtime and Sundays and Saturdays, and like, honestly, to me, as when we give a tax levy like we do to the county, why doesn't it just come out of that? Why are we paying all these extra little bits of money to the county when they're using our money to get the things that they get for us?
First of all, I'll ask, good question. First of all, I'll ask Tracy to comment on Mike's figures.
Through the mayor, the monthly costs are rolled into the total amount. They're not in addition to the fixed fee. This is how we operated in the previous years. The monthly, we have a set number of hours that they dedicate to the township. I believe it's 26. I wouldn't ask for more hours to be applied to us, and it's highly unlikely that we'd ever have an emergency GIS situation where we need them to work overtime or on holidays. So I think they just added that to the agreement so that we're fully aware of if we asked for extra work, then that's how that would be applied. But I don't anticipate we would go over the amount budgeted. And if we were to find ourselves in a position, we would have to come back to council to ask for approval. So we would have to stick within the budgeted amount. Thank you.
Thank you. I'll answer your other question, Mike. I'll try to anyways, regarding why it's an extra charge. My understanding is that they offer this service to some municipalities that don't have that service themselves. And I believe that the Coburgs and the Port Hopes, as an example, probably have a department that handles GIS, where we don't have the full need for that. And so smaller municipalities tag along with the county and pay their share of that. Is that understood?
Yeah, no, I do understand that. I just, me personally, I look at, we give them, maybe 45% of our levy. And then we have to keep paying these extra little costs for other stuff that we're already giving them money for to buy this product to use for us. So it's like we're double paying them. And, we give them quite a bit of money, and probably not as much as some of the other bigger municipalities do when out of their levy. So now would it be, could the mayor make a motion at county that this kind of cost comes out of the levy? It's not an added cost.
I can do that, sure, but it won't be accepted by the rest of them because they're already paying their own GIS in their own municipalities.
How many out of the 7 municipalities are on this program with them?
Right now, I don't know.
Okay.
I can find out for you though.
It just seems like it's a huge cost to the municipality for this here. Could we buy our own, run it ourselves, pay for it ourselves over 3 or 4 or 5 years? The amount that we're paying for this, I don't know. Is that a question?
That's a fair question. Anybody got any thoughts on that? Tracy?
Through the mayor, I would expect that you would need to hire a staff person to do the work. I would expect that would be a considerable amount, probably more than what we are paying to have the shared resource. We pay our appropriated share for the software. It's split between all of the member municipalities. So if we were to purchase the software on our own, we would have to pay the full cost of that rather than pay the proportionate share. So I would expect it would be a higher cost to operate on our own than to share that it's a very technical service. I had trained in GIS 20 plus years ago, and it's a highly technical skill. If you don't use that language, you're not going to be able to use it in the future. I can do some limited mapping, but at the extent that we need, it's a service that I appreciate having. And it allows for us to provide additional resources to the public, like we're working on online mapping that they're helping us through an inquiry portal that was mentioned in the planning update report. So it would be a service that would be hard to replace at the cost that we are paying. Thank you.
Do you know how many staff the county have in GIS?
Um, I would say there's at least 5. I would have to get the full number.
Be interesting. Go ahead, Councilor Neal.
Just to pick up where our planner left off, I think this is an essential service, and if we're going to have a planning department, our planners need access to this. And I'm pleased to see it's here. If I may, through you to Councillor Ainsworth, that we have already asked, and the county has already, I believe at their meeting last week, agreed that they would look at where shared services could be looked at for cost reductions. So they're already in the process of doing that.
Thank you. Okay, so it was moved and seconded by Councilor O'Neill and seconded by Councilor Ainsworth. All in favor? Opposed? Motion is carried. Next is 13.4 to appoint advisory committee members. Bylaw 35-2025 to appoint advisory committee members. It is recommended the Council of the Corporation of the Township of Allen-McCullough enact as follows. That bylaw 35-2025 being a bylaw to appoint advisory members be given a first, second, and third reading and finally pass this 22nd day of April 2025. Mover and seconder. Moved by Deputy Mayor Silver, seconded by Councilor Ainsworth. Any discussion? All in favor? That motion's carried. Okay, we're going into closed meeting. Thank you very much, ladies.
The heat up.
What's that? I'm gonna wait till I guess it should be done when the people are here. I guess I need a motion to go into closed. Moved by Councilor Booth and seconded by Councilor Ainsworth. All in favor? Motion's carried. We'll take 5 minutes to get everybody where they have to go. The council received a report enclosed on staffing matters. Staffing were provided direction and will be proceeding as directed enclosed. Mover and seconder. Moved by Councilor Ainsworth, seconded by Councilor Booth. Further discussion? All in favor? Motion's carried. Now we're going to 15, confirming bylaw number 36-2025. Confirming bylaw is recommended the Council of the Corporation of the Township of Allen-McCullough enact as follows. That bylaw 36-2025 being a bylaw to adopt the proceedings of the municipal planning regular council meeting held on the 22nd day of April 2025 and to authorize its execution be given a first, second, and third reading and finally pass this 22nd day of April 2025. Mover and seconder. Moved by Councilor Booth, seconded by Councilor Ainsworth. All in favor? That's carried. Motion to adjourn. It is recommended the Council of the Corporation of the Township of Allen-McCullough enact as follows. That the municipal planning / regular council meeting held on April 22nd, 2025 be adjourned at 1:09 p.m. Moved by Councilor O'Neill, seconded by Councilor Booth. All in favor? That's carried. Thank you, everyone.